Assalamu alaikum. Welcome back to our channel, Pakistan Zindabad, the next world superpower.
We're so glad you could join us again.
Today, we have something, well, truly special. We're about to embark on this incredible journey through legal history, and I have to say, when I first went through our source material for this, I was genuinely shocked.
It's the kind of history that really reframes what you think you know.
Absolutely. We're doing a critical deep dive into what might be the most foundational principle of justice there is, the right of an accused person to defend themselves.
And, just as importantly, the duty of the state to make sure that defense is actually possible.
We're drawing on a really fascinating compilation of legal precedents. The work is titled The Inalienable Right to Counsel, a Global Legal Heritage, and it's based on research found in the book True Courtroom Stories, researched by Mr. Zahir Ahmad Mir.
And for those of you who follow the source material closely, you'll know this specific exploration is labeled as Episode 89. That alone should tell you just how deep and rich Mr. Mir's research is.
It's incredible. And our mission today, it isn't just to summarize these amazing documents. We want to synthesize them.
Right. We're going to connect the dots. We're linking these historical decrees from 12th century Morocco all the way to landmark American constitutional law.
And then bringing it right into the present day with modern legal rulings from Pakistan.
Okay, so let's unpack that a bit. Because I think most people, when they think about the right to a lawyer, they assume it's a modern invention.
Of course. You think of something hammered out in a, 20th century courtroom, a recent constitutional achievement.
But this source material just completely challenges that assumption. The core argument we're investigating today is simple, but it is so profound.
And what is that?
That justice, true justice, absolutely cannot exist where the accused cannot defend himself.
And what's so fascinating here, and we'll see this as we go, is how these different legal systems, separated by centuries, by oceans, by different religions, they all somehow arrived at the very same ethical conclusion.
It's uncanny. It shows that the need for a defense isn't just a cultural idea or some political gift from a government.
No, it's something more fundamental.
It's a universal, inalienable human principle. It's a core ethical mandate for any system of law that wants to be seen as legitimate.
So, to explore that universality, we've set up a kind of historical trilogy for you today.
A journey in 3 parts.
Exactly. We'll start by setting a benchmark in medieval Fez, Morocco. We're going to examine this sacred declaration from a judge, a Qadi.
Then we're going to jump forward in time to the revolution in criminal law that was ignited by a single handwritten petition from a poor man in mid-20th century America. We'll be looking at Gideon v. Wainwright.
And finally, we'll see how that exact same principle is upheld, how it's codified, and how it's defended today in the modern courts of Pakistan.
Tying all 3 of these very different worlds together under that one powerful idea, due process.
Okay, let's dive in. Let's immerse ourselves in the first scene. I want you to picture it. We're going back to the 12th century. We're talking around 1100 AD.
So a long time ago.
A very long time ago. And we're in Fez, Morocco. Now, Fez at this time wasn't some backwater. It was an intellectual powerhouse.
A major center of learning, of trade, of really sophisticated legal thinking.
And we find ourselves in the court of a judge named Qadi Abu Umar. He's presiding over an extremely serious matter, a murder case.
The stakes couldn't be higher. Life and death are literally on the line.
And what's so compelling about the source material here is that it doesn't just focus on the crime itself. It zeroes in on the practical, procedural requirements of justice.
This wasn't just some abstract legal debate for the Qadi. It was a crisis of fairness playing out right in front of him.
So what happened? An accused individual is brought before the court, facing this capital charge, but the Qadi immediately notices 2 huge problems.
2 deficiencies that, in his mind, threatened to make the entire trial illegitimate before it even began.
And these really highlight that timeless problem of the lone individual standing against the power of the state. So walk us through them. What were they?
Well, at first it was pretty straightforward, at least for the time. The accused had no legal representation. He couldn't afford a lawyer.
Which was common for the poor back then.
Very common. But it's the second deficiency that's really crucial. The court record notes that the man was, and I'm quoting the idea here, unable to articulate a defense.
So this isn't just about him choosing to stay silent.
Not at all. This was a functional incapacity. Maybe it was due to illiteracy, maybe shock or mental distress, or maybe he just had no comprehension of the legal process he was caught in.
Whatever the reason, for all intents and purposes, he was incapable of participating in his own defense.
And that distinction, The inability to articulate a legal argument is absolutely critical. You have to understand, any complex legal system, even one based on 12th century Islamic jurisprudence, or fiqh, it runs on specific rules,
It has its own language.
a specialized language,
Yeah.
procedures for evidence, for cross-examining witnesses. If you, as the accused, can't speak that language, the system isn't just confusing, it's designed to crush you.
It creates this massive power vacuum in the courtroom.
It does. On one side, you have the prosecution.
Yeah.
They're organized, they're rational, they're backed by all the resources of the state.
And on the other side,
If the defense is silent or just incomprehensible, the trial stops being a search for truth. It's no longer an adversarial process. It just becomes a formality.
a rubber stamp on the prosecution's story.
Precisely. And Qadi Abu Umar saw this immediately. He understood that silence or incomprehension from the accused was the same as denying them a trial altogether.
So let me push back on that for a second. If the court was, let's say, already convinced of the man's guilt based on the evidence, why did the Qadi feel this intervention was so necessary? Couldn't the court just look at the facts and find the truth on its own?
That's a fantastic question, and it gets to the philosophical depth of Islamic law at the time, which was, frankly, very different from any European system.
Was so?
Well, you have to remember, many European courts at this time were still relying on things like trial by ordeal.
Right, like holding a hot iron to see if God would heal the wound and prove your innocence.
Exactly. Methods that invoke divine judgment. The tradition of the Qadi courts, however, was different. It placed a huge emphasis on rational inquiry, on evidence, and on clear judicial procedure.
So the judge's role was bigger than just being a fact finder.
Much bigger. His role was to ensure procedural fairness according to sacred law. He determined that finding the truth through an oppressive or unfair process results in tainted justice. The outcome is meaningless if the process is corrupt.
So for him, providing a lawyer wasn't just an option.
It was the only ethical path forward to legitimize the entire proceeding.
And this is what sets the stage for his revolutionary declaration. Let's break down the 3 core principles he established. The source notes, they were remarkably forward-thinking.
The first principle is foundational. Every accused has the right to be heard.
This establishes a basic level of dignity, right?
Exactly. It prevents what you could call silent condemnation. Even if the evidence seems overwhelming, the system has to recognize the accused as a human being, as a moral agent who is capable of offering a rational defense.
Right. Even today, people in adversarial systems sometimes struggle to fully realize.
Sadly, yes. But it's the second principle that's the real game changer. This is the one that establishes a precedent for modern legal aid.
Okay, what is it?
The state must provide a representative if he cannot.
Wow. In the 12th century. So what did the state even mean in this context?
It meant that the Beit al-Mal, the state treasury, or the court itself, had to bear the financial and the institutional responsibility for this.
He didn't just suggest it as an act of charity. He institutionalized legal aid. He mandated it.
He mandated it. He said that an individual's inability to afford a defense doesn't absolve the court of its sovereign duty to ensure justice. It completely flips the burden of responsibility onto the institution of justice itself.
That is astonishingly advanced for the 1100s, and it leads directly into his third and most powerful declaration.
Right, which moves this whole concept beyond just procedural rules and into the realm of moral philosophy.
Yeah.
He declared, judgment without defense is oppression.
Let's really focus on that word, oppression. He's not saying it's a mistake or a procedural error.
No.
He's saying it's tyranny, cruelty, a moral crime committed by the state against one of its own people.
Precisely. The Qadi framed the absence of a defense as a moral wrong against humanity itself. He argued that if the court uses its immense power, its authority, its resources, its legal expertise to crush an individual who can't speak for themselves,
then the judgment that comes out of that process, no matter the facts, is an act of structural cruelty.
the institution, by failing to provide that necessary counterweight, becomes the oppressor.
This dramatically expands the judge's mandate. He wasn't just interpreting the law as it was written. He was actively fighting the inherent injustice built into the system that favors the powerful.
And his action backed it up. He didn't just make the declaration. The sources say he appointed a court scholar, a highly respected jurist, a faqih, to represent the accused.
And critically free of charge.
Free of charge. And think about who he appointed. Not just some junior clerk, a recognized expert in Islamic law. This implies that the quality of the state-provided defense have to be high. It has to be competent counsel, not just a warm body standing next to the accused.
So let's synthesize this first crucial section. The conclusion our source material draws is just so powerful. This foundational principle of court-appointed counsel, paid for by the state, using a high degree of legal expertise.
All happened in Fez, Morocco, centuries before it became a standard anywhere else. It established this universal benchmark for justice that was rooted in sacred principles of human dignity.
Okay, so we're going to use this 12th century precedent as our standard bearer for the rest of this deep dive.
Exactly. For the rest of our discussion, we are looking for the echoes of Qadi Abu Umar's profound understanding of fairness in the legal systems that followed.
All right, now we take that ancient realization, that moral duty of the state to balance its own power, and we are going to vault forward in time, all the way to the mid-20th century.
From Fez to Florida.
To the seemingly very different world of the American constitutional system. The year is 1963, and the U.S. Supreme Court is about to hear a case that will fundamentally alter criminal procedure across the entire nation. Gideon v. Wainwright.
The jump in time and geography is huge, but the core story is chillingly familiar. It's, once again, the isolated individual against the immense machine of the state.
The case revolves around a man named Clarence Earl Gideon. He was accused of breaking into a pool hall with the intent to commit a misdemeanor.
Which, under Florida law at the time, was a felony.
And Gideon was poor. He was indigent. When he showed up in court, he told the judge, based on his own simple understanding of fairness, that he needed a lawyer but couldn't afford one. He asked the judge to appoint him one.
And the judge refused.
Why? On what grounds?
The refusal was based on the legal precedent of the time, a 1942 Supreme Court case called Betts v. Brady.
And what did that case say?
Betts held that the constitutional requirement for an appointed lawyer only applied in capital cases, so where the death penalty was on the table, or in cases with what they called special circumstances.
Special circumstances? Like what?
Things like if the defendant was mentally incapacitated or illiterate or very young. Since Gideon's felony wasn't a capital crime and he didn't fit those other categories, the judge just followed the standard. He told Gideon, "You have to represent yourself."
And this is where we get that powerful human story that just perfectly illustrates the entire problem. Gideon, he tried his best, but he was a layman. He was facing professional, trained prosecutors.
He had no idea how to conduct a proper cross-examination, how to object to improper evidence, how to make a compelling closing argument to the jury.
He was, unsurprisingly, quickly convicted and sentenced to 5 years in prison.
But from his prison cell, he did something remarkable. He filed a handwritten pauper's petition, a formal request called a writ of certiorari, and sent it to the U.S. Supreme Court.
Just think about that for a moment. A man with no legal training, using prison stationery and a pencil, writing a legal argument against the entire state of Florida, and asking the highest court in the country to hear him out.
It's an incredibly powerful symbol of that individual's fight for justice against impossible odds.
And what happened next reshaped American law. The Supreme Court agreed to hear his case, and they overturned that old Betts v. Brady decision completely. They ruled unanimously for Gideon.
And in doing so, they held that the Sixth Amendment right to counsel had to be guaranteed in state courts, not just federal ones.
Okay, so this is where we need to get into the legal mechanics a little bit. How did they do that? Because the Bill of Rights, like the Sixth Amendment, originally only applied to the federal government, right?
Exactly. The key was a legal doctrine called incorporation. The Supreme Court used the Due Process Clause of the 14th Amendment, which was passed after the Civil War, as a kind of bridge.
A bridge to do what?
A bridge to incorporate the fundamental protections in the Bill of Rights, like the right to counsel, and apply them directly to state governments.
So the 14th Amendment essentially stopped individual states like Florida from having their own lesser standards of justice for these core rights. It forced a minimum standard of fairness across the entire country.
Precisely. And in making that decision, the Supreme Court delivered a quote that our source material rightly emphasizes. It's a quote that is functionally identical to the moral declaration Qadi Abu Umar made 800 years earlier.
What was it?
Lawyers in criminal cases are necessities, not luxuries.
Let's spend a moment on that phrase. Necessity versus luxury. Why is that specific wording so important in constitutional law?
Well, because legally, a luxury is an extra. It's a benefit you can have if you can afford it, but the state can deny it to you without violating your rights.
But a necessity.
A necessity is something that is absolutely required for the system to function correctly. By defining a lawyer as a necessity, the court was saying that without one, the entire judicial process fails to meet the standard of due process. It becomes fundamentally unfair.
And if the trial itself is fundamentally unfair, then the outcome, the conviction, is unconstitutional, no matter if the person was factually guilty or not.
You got it. It reinforces that core idea. The procedure is justice. Justice Black, who wrote the opinion for the court, said that even the most intelligent layman is no match for a professional prosecutor. The court was directly acknowledging that power imbalance we talked about.
So now let's draw that direct line back to Fez, just as you promised. The principles are just echoing across the centuries.
They really are. You have two completely different legal traditions: Islamic law, rooted in sacred text and interpretation, and Anglo-American common law, rooted in constitutional history.
And yet both jurists, the Qadi and the Supreme Court justices, arrived at the exact same ethical mandate.
Qadi Abu Umar acted because he saw that denying a defense was oppression. The Gideon court acted because denying a defense was a denial of due process. The language is different, but the recognition is identical.
That a complex legal system inherently crushes the unrepresented, and the state must step in to balance the scales.
Right. But let's introduce a little critical friction here because our audience expects it. The Gideon ruling was revolutionary, yes, but it mandated lawyers for all felony cases. What about the millions of people who face misdemeanors or other lower stakes crimes?
Did the court in 1963 really fix the problem for every poor person in the system?
That is the critical limitation. And the Supreme Court did address this later, in other cases like Argersinger v. Hamlin and Scott v. Illinois.
And what did they decide?
They eventually extended the right to counsel to misdemeanors, but, and this is a big but, only if the defendant is actually facing a jail sentence, no matter how short.
So if you're charged with a minor crime that only carries a fine, you still don't have a guaranteed right to a state-paid lawyer.
That's right. So while Gideon was a massive step for the most serious cases, that perfect universal ideal established by Qadi Abu Umar, that no judgment without a defense is valid, is still being realized piece by piece in the U.S. system, is often constrained by the practicalities of budgets and resources.
It shows that even in the most developed legal systems, that negotiation between the ideal of perfect justice and the reality of limited resources is an ongoing struggle.
The principle is clear. It's the scope of its implementation where the fight continues.
Okay, so we've established the ancient moral benchmark in Fez, and we've seen the constitutional revolution it mirrored in the U.S.
So now we shift our focus to the modern context. We're going to examine how this universal principle is codified and actively defended in a contemporary legal system. Specifically, we're looking at Pakistan.
And this is so important because it shows this isn't just ancient history or an American issue. It's a living, breathing part of modern post-colonial law. It shows that commitment to balancing state power is an active, ongoing judicial project.
Absolutely. So our source material outlines a really robust set of guarantees that Pakistan's courts provide to an accused person.
What are they?
Well, first, there's the fundamental right to defense. That's the philosophical starting point. Same as in Fez, same as in Florida.
The bedrock.
Exactly. But second, and this is where you can really see the maturity in the jurisprudence, is the guaranteed right to time and facilities for counsel.
Now, that procedural guarantee time and facilities, that's a huge expansion of the right itself. It goes beyond just having a lawyer in the room. It speaks to the quality of the defense.
It really does. I mean, think about it. A lawyer who gets a case file 5 minutes before a trial starts can't offer a competent defense. It's impossible.
It's just a token representative at that point.
Right. So this provision ensures the accused gets a lawyer who has adequate time to actually do their job, to consult with their client, to gather resources, to review the state's evidence. It elevates the standard from just presence to effectiveness.
Which echoes Qadi Abu Umar's decision to appoint a high-status court scholar, not just anyone.
Precisely. And the third guarantee connects right back to that core problem of poverty. The right to state-paid defense in serious cases.
Okay, so this institutionalizes public defense funding within the modern Pakistani legal structure. Now, the sources cite specific Supreme Court precedents for this. They look a bit like alphabet soup, so can you break them down for us?
Of course. The sources cite PLD 2005 SC 62 and also rulings from SCMR in 2018.
What do those letters mean?
So PLD stands for Pakistan Legal Decisions. It's one of the oldest and most respected systems for reporting legal judgments in Pakistan from the Supreme Court and the high courts.
So when we see a citation like PLD 2005 SC 62,
it means the ruling is in the Pakistan Legal Decisions Report from the year 2005. It's issued by the Supreme Court, or SE, and it starts on page 62. It shows a clear, formal commitment from the highest court in the land.
And SCMR?
SCMR is the Supreme Court Monthly Review. It's another authoritative report that focuses just on Supreme Court judgments. The fact that the source mentions multiple SCMR rulings in 2018 about the right to counsel.
Tells us this isn't some old, settled issue.
Exactly. It's a continuous legal debate. The courts are constantly testing, reaffirming, and even expanding these rights in very specific, complex, modern cases.
So these aren't just abstract ideals written in the Constitution. They are principles that the Supreme Court of Pakistan is actively upholding and enforcing.
That's right. But let's go back to that phrase you mentioned, state-paid defense in serious cases. We just talked about how Gideon mandated counsel for all felonies. Why the distinction here with the focus on serious cases?
It feels like a practical constraint, doesn't it? The ideal clashing with the reality of running a country.
I think that's a fair assessment. While the philosophical ideal of Qadi Abu Umar or even Gideon is universal counsel wherever liberty is at stake, the reality in many nations is resource scarcity.
So focusing on serious cases is a way to prioritize.
It's a judicial mechanism to allocate limited resources effectively. It makes sure that this absolute critical protection, the counterweight to the state's power, is applied where the stakes are highest, where the potential loss of liberty is longest or the penalty is most severe.
So it maintains the moral spirit of the Qadi's ruling, which was, after all, in a capital murder case.
Precisely. So while the scope might be a bit narrower than the absolute ideal, that core principle, that poverty cannot mean defenselessness when you're facing grave charges, that remains completely intact.
It shows a judiciary that is constantly mediating between that ideal of universal justice and the logistical demands of a large modern nation.
And that mediation, proven by those 2005 and 2018 Supreme Court rulings, it just confirms that the court's duty to ensure a fair hearing for the defenseless is paramount. It's the ultimate check against potential oppression in the modern state.
Okay. We've spanned centuries, we've crossed continents, and we've seen the same struggle and the same fundamental resolution in three incredibly different legal worlds.
So this is where we need to synthesize everything. We have to move beyond just saying, oh, look, a parallel, and really dig into the philosophical heart of why this parallel even exists.
And the legal sources we've looked at, they distill this entire journey down into one singular, powerful statement. It's the ratio decidendi, the ultimate reason for the decision, that rings true in Fez, in Florida, and in Pakistan.
Justice cannot exist where the accused cannot defend himself.
Let's analyze the definition of justice that's implied there. It's not about a specific outcome.
No, it's not. It's a specific kind of justice. It's procedural justice. The principle is that the process itself must guarantee fairness, dignity, and a level playing field. The outcome, whether it's guilt or innocence, is secondary to the famous of the journey to get there.
So if that power imbalance between the individual and the state is too great, the process itself becomes corrupted.
And if the process is corrupt, the final judgment, even if it happens to be factually correct, has no legitimacy, not in the eyes of the law and, just as importantly, not in the eyes of the public.
The right to counsel, then, is the ultimate guarantor of that legitimacy.
It is. It's the institution of the state, recognizing its own inherent danger. A state that is allowed to prosecute people without providing them a meaningful way to fight back. That state turns its judicial system into an instrument of raw power, not law.
And this leads us directly to the moral lesson that our source material provides. To deny a defense is to deny humanity. Why humanity? Why not just liberty or rights?
Because without representation, the accused person is reduced to an object. They become a file, a case number. They're stripped of their ability to use their reason, their agency, to push back against the state's narrative.
The legal system sees evidence, the prosecutor sees a crime.
But the defense lawyer's fundamental job is to reintroduce the humanity into that equation, to bring in the context, the rights, the counter-arguments of a living, breathing person.
So denying someone a lawyer is a form of objectification. It reduces a person to just a silent variable in the equation of guilt.
And that silence, as Qadi Abu Umar declared 900 years ago, is oppression. It's the system acknowledging that the state, with its police, its prosecutors, its vast resources and specialized knowledge, is this overwhelming monolithic force.
And the individual facing it, especially if they're poor or uneducated or marginalized, they're functionally helpless.
So the state-provided lawyer is the only viable counterweight to that immense institutional power. It's the system correcting for its own overwhelming strength.
So the big question then is, why does this parallel exist across cultures and time? Is it natural law, divine law, or just the practical necessity of running a complex state?
I think the evidence from our sources suggests it's a mix of all three, but it's driven by that pragmatic necessity.
In what way?
Well, in Fez, it was framed through sacred law, recognizing a divine duty of care for everyone in the community. In the U.S., it was framed by the Constitution, recognizing the need to legitimize the government's power over life and liberty.
And in modern Pakistan.
It's framed by a modern constitution, interpreting the rule of law. But all three recognize the same basic truth. When you create a complicated adversarial system of justice, you simultaneously create a moral debt to make sure every single citizen can actually navigate that system.
The profound legal truth, then, that we can draw from all this is that protecting the accused is really the benchmark of a civilized society.
It proves that justice isn't just about punishing the guilty, it's about protecting the defenseless while you punish the guilty.
And seeing these same principles arise independently in systems so far apart, it just affirms that this is a universal requirement for any society that claims to value the rule of law over brute force.
It's just fundamental.
What an extraordinary deep dive. We started in the medieval law courts of Fez.
With Qadi Abu Umar's sacred declaration against oppression.
Then we vaulted to 1963 America, and we saw that same principle validated through the constitutional revolution of Gideon v. Wainwright, which declared that a lawyer is a necessity, not a luxury.
And then we brought it home, seeing its robust, ongoing application in the legal framework of modern Pakistan, constantly reaffirmed by Supreme Court rulings like PLD 2005 SC 62 and the SCMR 2018 cases.
The overwhelming evidence, all drawn from the incredible research compiled by Mr. Zahir Ahmad Mir in True Courtroom Stories, it all leads to one single, unshakable conclusion.
That the duty to provide a defense is a core, non-negotiable function of justice.
So as we conclude, let's return to that fundamental problem that started this whole legal evolution in the first place. That radical imbalance of power between one person and the entire resources of the state.
And that imbalance is still changing. It's still evolving. So let me leave you with a final provocative thought.
Please do.
If the Qadi's response to the problem in his time was to provide a legal scholar, the highest form of expertise he had available, what is the equivalent today? What does the right to counsel look like in the age of digital crime?
Or in the near future, with AI-driven legal systems.
Exactly. If the state is using massive data analysis and complex algorithms to build its case, or using forensic science that requires a PhD to understand and challenge.
Does the court now have a duty to provide the accused with access to that same level of specialized technological defense, just as Qadi Abu Umar provided access to an expert in sacred law?
The ultimate safeguard of due process might not just be the presence of a lawyer anymore. It might be access to the competency required to truly counter the state's modern resources.
The tools of power change.
But the moral imperative to balance them, an imperative we can trace back to 12th century Morocco, is eternal. That's something profound for you to consider as you digest all of this.
Thank you so much for joining us on this deep dive into the inalienable right to counsel. We'll see you next time.